see questions in the RTP which look similar but are a little different? Does it get you excited, or does it get you tensed, or does it get you like whatever? So do tell me about that. So today we are here discussing the RTPs of Jan 26 paper. IC has issued the RTPs. So we are going to discuss that. And you already know, whenever I talk about discussion of questions, we generally discuss the practical questions, because theory questions, there is nothing to discuss. It's just a direct answer. So again, obviously, we are going to discuss the practical questions that were there in the RTP for the Jan 26 exams. The first chapter is IRF, and we know we have direct questions from this. And we'll just definitely read the questions though. Describe the major functions of the RBI in regulating the Indian economy. How does it manage the currency payment system and economic development? So if you remember RBI ka the whole thing, that it is the central bank in India's economic system. It is under the ownership of Ministry of Finance, manages the money, and also the corporations that it has, opened up the payment, settlement. So all that we have to write here. Next is Indian Contract Act. Mr. Naman is an auctioneer. He advertised in a leading newspaper. Advertisement is what? When I talk about advertisement is what? Advertisement is what? It's an invitation to offer, right? Leading newspaper, that an auction would be held. Auction again is an invitation to offer, right? Would be held on the 17th of April 25 in Agra for the sale of some office furniture. Mr. Khanna read the advertisement and travelled about 500 kilometers to attend the auction. When he reached the place of the auction, he found that the furniture has been withdrawn from the sale. Khanna sued Naman for the loss of his time and expense. State with reasons whether Khanna can claim compensation. Can Khanna claim compensation? No, because we already know invitation to offer. I'm not bound to perform at all. So in case of an invitation to offer, I'm not bound to perform, so I will not get any compensation whatsoever. So what provisions will you write? You know the 3 paragraphs. So here in the first paragraph, it's very evident the question is about invitation to offer. So you should actually explain invitation to offer. Abhimanyu, a businessman, lost his important documents at a crowded railway station. Ramesh, a passerby, just one second. Ramesh, a passerby, voluntarily collected the documents and returned them safely to Abhimanyu without expecting any reward. A week later, impressed by Ramesh's honesty, voluntarily collected the documents. So the act was done voluntarily and returned them safely to Abhimanyu without expecting any reward. A week later, impressed by Ramesh's honesty, Abhimanyu wrote and signed a promise to pay him 50,000 as a reward. So the work was already done and then he promises to pay. Can I say this? Yes. Compensation for past voluntary services, right? Later, Abhimanyu refused to pay, arguing that the act has already been performed voluntarily and therefore did not constitute valid consideration. When the promiser has rendered voluntarily services for the promisee and the promisee promises to compensate, it's a valid contract. So can Abhimanyu refuse? No. Whether Abhimanyu is liable to pay? Yes, Abhimanyu is liable to pay because it is a valid contract, right? Vikas, a businessman from Delhi, entered into an agreement with Reddy, a trader from Hyderabad, to smuggle, illegal, unlawful. Try to, whenever you're solving question, try to identify like this, break it into points and try to identify. A large consignment of gold into India in violation of custom laws. As per the terms, Reddy would arrange the smuggling operation while Vikas promised to provide financial support and safe storage facilities. Both agreed to share the profits equally. The agreement also stated that Reddy would invest a portion of his profit in Vikas' legitimate textile business. So this profit which is coming from unlawful means he will invest it in the lawful business of Vikas. After the first successful operation, a dispute arose between the parties. Vikas received the smuggled goods but refused to share the profits, arguing that the agreement was unlawful. Reddy filed a suit for enforcement, claiming that at least the lawful portion of the agreement relating to the textile business should be upheld. Decide whether the agreement is enforceable under the Indian Contract Act. Okay, first there are two contracts, the smuggling contract, and the second is investing the profits of the smuggling business into the lawful business. First of all, this is too unlawful, so it's not enforceable. Second, this is a lawful business. This is enforceable. But here I am investing the profits which I am deriving from unlawful business. So this profit is also unlawful. So there is a lawful part and there is an unlawful part. But both the parts are not separable. And when both lawful and unlawful parts are not separable, I repeat again, when both lawful and unlawful parts are not separable, the contract is what? Completely void. At least the lawful portion of the agreement relating to the textile business should be upheld. Decide whether the agreement is enforceable. No, the agreement is void and so not enforceable. Mr. Lal, a well-known builder, entered into a contract with Mr. Kumar, a property developer, to construct a large shopping mall in Jaipur for a total consideration of 10 crores to be completed within 18 months. After the work began, both the parties mutually decided to alter the nature of their agreement. By mutual consent, a new contract was substituted under which Lal would instead construct a five-star luxury hotel on the same land for an increased price of 12 crores. This new agreement expressly cancelled the earlier mall contract. So here the old contract is cancelled and in place of the old contract a new contract is made. This is what? This is what? Novation, right? This is novation. However, 6 months after the new agreement, so when in case of novation, can you now enforce this contract? Once you have cancelled the old contract, can you later enforce it? No. However, 6 months after the new agreement was executed, the state government, under its urban development policy, passed a law prohibiting the construction of hotels in that particular commercial zone, though the construction of shopping malls was still permitted. So this old contract was for shopping mall and this was cancelled and a new contract was made for hotel. 6 months, the state government under its passed a law prohibiting the construction of hotels. So this contract is now what? Impossible to perform. Can I call it supervening impossibility? Yes, because it is beyond the control of the parties. In that particular commercial zone, though the construction of shopping malls was still permitted. Due to this prohibition, Lal stopped the construction work and informed Kumar that the contract has become impossible to perform. Kumar, however, filed a suit against Mr. Lal for breach of the new contract, demanding damages on the ground that Mr. Lal has failed to perform. Okay, Mr. Kumar filed a suit against. Do you think this suit is justified? Breach, is it breach of the new contract? No. Why? Because it has become impossible to perform. Demanding damages on the ground that Mr. Lal has failed to perform. Whether Mr. Lal is liable for breach of contract or whether the contract has become void. This is correct, this is not correct. So here you should write about novation a little bit and basically you should write about supervening impossibility, right? These are the two things that you have. So these are the two things that you have to write about, right? So, is the contract discharged? Yes, the contract is discharged. And If the contract is discharged, is Mr. Lal liable for breach of contract? Not liable. Mr. Ramesh delivered his gold ornaments to a jeweler, Mr. Arun, for polishing. Arun kept the ornaments, gave his delivered. So this is what? This is bailment. Arun kept the ornaments in the locker of his shop and locked the premises before leaving. Unfortunately, during the night, some thieves broke into the shop and stole the ornaments. When Ramesh asked for the return, Arun expressed his inability and stated that he has taken as much care of the goods as he would have taken of his own property. Now, in case of bailment, it is the duty of the bailee to take reasonable care of the goods. Right? And did he take, see here it's written, he kept the ornaments in the locker of his shop and locked the premises. So he has taken proper care. He has taken that care that a man of ordinary prudence would. So he has taken proper care. When Ramesh asked for the return of the ornaments, Arun expressed his inability and stated that he has taken as much care of the goods as he would have taken. This is correct. Ramesh, however, claimed compensation for the loss on the grounds that the ornaments were delivered under and that the bailee was bound to return them. Is Arun liable to compensate? No. When he has not taken proper care of the goods, he would be liable to compensate. But here he has taken proper care of the goods. I have taken proper care of the goods. I am not liable. Discuss in details the rule regarding the enforcement of contingent happening becomes valid when the event happens, that non-happening third-party impossible events. An agency may be terminated by the acts of the parties or by operation of law. Explain the statement and which cases agency. Revocation of authority by the agent or the principal by giving a notice, renunciation by the agent. In all of these cases, you just don't write that. You also write if there is a loss due to this, the person will be given the loss. Please do, because if it's a 7 marks, you should write it properly. Then by giving on the expiry of the business, on the expiry of the time, sorry, when the business comes to an end, by the insolvency of the principal, death or insanity of the agent or the principal. Discuss the essential conditions that must be fulfilled for a valid contract of guarantee. In case of a contract of guarantee, it may be oral or written. Then consideration is not given to the surety, but the consideration given to the principal debtor acts as a guarantee for acts as a consideration for the surety. Then in case of guarantee, there is already an existence of liability. Then in case there should not be any fraud or misrepresentation in obtaining the contract of guarantee. Then after that, if one of the co-sureties refuses to join, then the others who have signed will be liable. And if it was conditional that we will be liable only when everyone signs, then the others will not be liable. Okay, the Sale of Goods Act. Classify the following transaction according to the types of goods they are. A wholesaler of cotton has 100 bales in his godown. What type of goods are these? It's the stock of goods unascertained. He agrees to sell 50 bales. This is unascertained goods. And these bales were selected and set aside. So obviously, this is ascertained. A agrees to sell to B 1 packet of sugar out of the lot of 100 packets lying in his shop. 1 packet out of 100. So this out of 100 is selling 1 packet. The goods are not taken out. So it is what? Unascertained. We have done the same question in the class. He agrees to sell to S all the apples which will be produced in his garden this year. Future goods or contingent? Future. If it was conditional, then it would be contingent. Rahul, a wholesale trader in Delhi, placed an order with Mr. Kapil, a textile merchant, for 50 rolls of premium silk cloth at an agreed price. It was clearly mentioned that the cloth should be of premium quality and suitable for manufacturing wedding garments. Mr. Kapil delivered the goods on the scheduled date. Here it is description, right? Here it is also the reason of the purchase. Mr. Kapil delivered the goods on the scheduled date. On casual examination at the time of delivery, the rolls appeared to be fine. So Rahul accepted them. Rahul accepted them. However, later, while cutting and using the cloth for tailoring, it was discovered that the rolls contained a mixture of synthetic fibers and had hidden defects such as small holes and stains. These defects made the cloth unfit for making wedding garments, causing heavy losses to Rahul. Now, here you would say, ma'am, see, I am telling you description, plus he told the purpose also for which he was buying. The question is more of based on the hidden defects or the latent defects in the goods rather than not suitable for the purpose for which it was bought. So, uh, appropriately, the answer we will write about description, right? Because we are not saying that it was the main foundation of this case is not that it was not suitable for his purpose. It is more of like the defects which were not visible to the eye. So when the sale is made by description and the seller deals in those type of goods, he must supply the goods which are of merchantable quality. Since the goods were synthetic fiber and had hidden defects which were makes them unfit, the goods are not merchantable. So when Rahul demanded a refund, couple refused, contending that Rahul had already inspected the goods. Here, one more thing. If while taking the goods, the buyer has examined the goods and there were defects which were visible to the eye, he cannot return. However, if there are defects which are not visible to the eye, he can return. Since the goods were, and it's given here very clearly, the rolls appeared to be fine, so Rahul accepted. So it was a hidden defect. So can he return the goods back? Yes, Rahul can return the goods back. So whether Rahul can reject the goods? Yes, he can reject the goods. He's not bound by the sale, right? Moving on to the next one, Mr. Varun, a laptop distributor, delivered 20 laptops to his friends, Mr. Rohit, on the condition of sale on approval or return basis. So it's given only. The question is about that. Within 10 days, Rohit neither returned the laptops within the stipulated period nor informed Varun of any rejection. Instead, he kept the laptops in his office showroom and sold 5 of them to Mr. Anuj. Okay. He neither returned the laptops within the stipulated period nor informed Varun of any rejection. It's a sale. If beyond the time period you don't return the goods, it's a sale. Instead, he kept the laptops in his office showroom and sold 5 of them to Mr. Anuj, claiming to be the absolute owner. Anuj purchased the laptops in good faith, paid full consideration, and even issued a receipt. After 15 days, Varun demanded the return of all the laptops, including those sold to Anuj. Rohit refused, arguing that he has acted as the owner. Anuj also defended himself, claiming that he was a bona fide purchaser for value. Varun, however, relied on the principle that no one can transfer a better title than that he himself has. Whether Anuj has acquired a valid title. Has Anuj acquired a valid title? Just one second. So, whether Anuj has acquired a valid title and whether Varun can recover the goods. So, see here, Varun gave Rohit his goods. Rohit did not return the goods back, nor did he tell him that I don't want to keep the goods. So, it's a sale. Now, Rohit sold these goods to some of these goods to Anuj. Is the sale valid? Absolutely valid. Why? Because this is already a sale. So, it's absolutely valid. So he is saying that no one can transfer a better title than he himself has. Does this even apply here? Not applicable. Why? Because R is the owner of the goods. So whether Anuj has acquired a valid title? Yes. Can Varun get the return? No, he cannot get the goods. Why? Because it's already a sale to Rohit. Is it clear to all of you? Yes? Discuss the rights of the buyer against the seller. So what are the rights of the buyer against the seller? Specific performance, damages for non-delivery of goods, refund of price, sue for interest, and there was one more. Sue for what all did I say? Sue for damages, specific performance. We've covered all. Clear? Explain the rules relating to passing of property in specific or ascertained goods. So they are asking you about specific or ascertained goods. So you have to write about the 3 specific goods in a deliverable state, not deliverable state, and if the seller has to conduct the test to determine the price. So moving on to Indian Partnership Act, Mr. Varun and Mr. Arun are brothers employed in private company in Delhi. Out of their joint saving, they purchased a plot of land in Noida and constructed 5 commercial shops. These shops were later rented out to different tenants. It was mutually agreed that both would equally share the monthly rent received. They also decided to contribute jointly towards property tax and repair expenses. One tenant defaulted in paying a rent of 50,000. Varun claimed the entire arrears from Arun, stating that both were partners in the property business. Are they partners? Renting. If you remember, we had discussed that renting of property is not a business and hence it's not partnership. Correct? And hence Arun, being one of the partners, was liable for the whole amount. Arun, however, refused and argued that they were not partners but only co-owners. He is correct. Therefore, he was not liable to pay Varun's share of the default rent. This is right. Right. So, Arun is only liable for his share. If it was partnership, then yes. But here, because they are co-owners, he is only liable for his share. So, whether Arun and Varun can be regarded as partners? No, renting of property is not partnership. M, N, and O were partners in a firm engaged in the transport business over time. N became mentally unsound and was incapable of managing the firm's affairs. O alleged that M was continuously guilty of misconduct and was misappropriating the firm's fund. Due to repeated dispute and loss of trust, O filed a petition in the court seeking dissolution of the firm. After the court ordered dissolution, M claimed that he still had a right to use the firm's truck and vehicles for his personal business. Examine whether contention of M is correct. So, whenever you write, depending on the marks, you might have to add a little portion. You can here write that court may order for the dissolution of the firm in case of, misconduct of a partner or perpetual losses or partnership, a partner becoming unsound mind. When a partnership is dissolved, every partner, including legal heirs of a deceased partner, have a right to finish the unfinished transactions of the firm so that the assets can be realized and the liabilities can be paid off. But no partner can use any property personally. Right? You cannot use the property of the firm personally. So is M's contention correct? No. Because the partners cannot use the property personally. If he gets that property, then he can, as surplus. If he gets that property, then he can. But otherwise, you cannot use it personally unless you get it as a surplus, as your share. Explain the rights of a transferee of a partner's interest. He will get his share of profits. He cannot interfere with the business. He cannot check, inspect, and copy. On dissolution, he will get his share, and to determine his share, he will be given a statement of affairs as on that day. Provisions relating to change of name of LLP, if it is identical, make an application to central government. Central government will order within 3 months change the name. If you don't change the name, then central government will allot a new name. Sunrise Infrastructure Limited was incorporated with the object of developing residential housing project as specified in its MOA. Board of Directors decided to invest a substantial part of the company's fund in speculating trading of shares of other companies. Was it given in the MOA? No. That means this act is against the MOA. And anything which is against the MOA is what? Ultra wires. Hoping to earn quick profits. When the shareholders questioned this act, the directors argued that since the company was duly incorporated and had wide powers of management, their decision was valid. Examine with reference to the doctrine of ultra wires whether the director's action is binding on the company. No. Why? Because it is ultra wires and hence it is void. So you have to write about ultra wires here. Bharat Infrastructure Limited was incorporated in India with 55% of its paid up capital held by central government, 20% by state government, and that remaining 25% by private investors. So government is holding how much? 75% of the paid up capital is held by the government. Can I call it as a government company? Yes. Some private shareholders argued that the government control was not absolute and therefore company should not be classified. Decide with reference. the claim is not valid as government is holding 75%. It's a government company, right? Okay. Can a non-profit organization be registered as a company under Companies Act? If so, what procedure does it have to adopt? Yes, it has to apply for the license to the central government. Central government will issue the license. The objectives has to be this. All of that you have to quote Section 8. Negotiable instrument. Mr. Anil drew a bill of exchange in Kolkata on Mr. Vimal, a resident of New York, and made it payable in Delhi. On maturity, the bill was dishonored and Anil sued Vimal in India, claiming interest at the rate of 18% as applicable in Kolkata. Vimal contended that his liability was governed by New York law, where the rate of interest was only 6%. Discuss the liability of Vimal with reference to the provision. Okay, first of all, if it is an inland instrument, Indian law will apply. But if it is not an inland instrument, then Indian law will not apply. To be an inland instrument, you have to be drawn in India and payable in India on a person resident in India. Here, it is drawn in Kolkata. This is fulfilled. Any one of this should be there. This is a resident of New York. This is not fulfilled. And it is made payable in Delhi. So that means this is fulfilled. Two conditions are fulfilled. It's an inland instrument. It is an inland instrument. Since it's an inland instrument, the laws of Indian laws will apply, right? Therefore, interest will be applicable at what rate? At the rate of 18%. Discuss the liability of Vimal. He must pay interest at the rate of 18%. Clear to all of you? Now, define the following instruments under the Negotiable Instruments Act. Bearer instrument is basically the person who is the, it's drawn as a bearer, or the last or only endorsement was in blank. Order instrument, it is payable to a specified person or to the order of a specified person, and the last endorsement was in full. Inland instrument, we just discussed, drawn in India and drawn on a person resident in India or made payable in India. Foreign instrument, which is not an inland instrument. With this, we are done with the discussion. I hope your studies are going well. Keep studying, keep learning, happy learning, and stay motivated. Thank you so much.